we're here on the bond violation. They were sentencing on the violation.
This hearing starts as a routine bond violation, but it quickly turns into a full-blown credibility crisis. A 21-year-old defendant, facing a drunk driving case with an accident and a prior positive alcohol test, stands before a judge who already gave her a break once. She was ordered to immediately report to community corrections and get fitted with a scram alcohol tether. Instead, days passed. Excuses piled up. Missed tests stacked into double digits. And now the court is asking one simple question. Are these life challenges or are they choices? Stay with this one, because this judge is about to draw a hard line between inconvenience and accountability.
Did you get the new report?
Yes, I did, Your Honor.
Is there anything you want to say before I?
Yes. But I'd like to start off. Ms. Wilson is a 22-year-old. She's very apologetic to the court. For the initial violation, she was upfront and honest about the dirty blow, and she admitted when presented to her. There was a delay for the tether, which I believe is what you're referencing on the report. The day of court, she did, that was April 17th, she did go to community corrections, but because she had her child with her, community corrections do not allow kids within the facility. She did not have a babysitter at that time, and she wasn't able to get the tether fitted that day. On the 18th and 19th, likewise, she did not have a babysitter. She also does not have a valid license right now, so she is not able to drive herself to the facility. She relies on others to help her out with rides. So that is why she wasn't able to get the tether fitted until Monday. She was going to try to go on the weekend, but since the community corrections is closed on the weekend, she wasn't able to do that. She is working full-time, been there for the last 4 years. She works, she also is enrolled inside school full-time, inside the nursing program, and she's a full-time mother. She has no one to really help her with watching the kid during the day. So we'd be asked that she be allowed to continue on bond while this case is pending.
Anything from the people?
We leave it on the court's discretion.
The problem that I have, Wilson, is that on the 17th, you admitted to the violations. We set the sentencing out to today. In the interim, because there was a dirty blow, I had told you to report to community corrections to get on a scram tether immediately. That was on the 17th. On the 18th, it was not.
This is the turning point. The judge isn't confused about logistics. He's evaluating credibility. On April 17th, she was ordered to report immediately and get on a scram tether. That didn't happen until late Monday afternoon, 5 days later.
That's a Friday.
And here's the legal issue. When someone is charged with drunk driving and already has a confirmed alcohol violation, monitoring is about public safety, not convenience. The court's concern isn't just that she was late. It's that during those 5 days, she wasn't properly monitored.
You just didn't
no
show
tether,
up.
no reliable SoberLink testing. So the judge asks the critical question, how can the court know she wasn't drinking over the weekend?
On Monday,
that gap matters
even if I
a lot.
Accept
so
your
I'll ask
rationale
you,
that you were
should
working,
parenting and work conflicts outweigh
and
the
that
direct
in terms
order?
of working,
Or does the order always come first?
It was not even until if I Monday of this week that in the late afternoon on Monday that you put yourself onto a scram tether. I'm trying to figure out why.
Can I talk? Yeah. I worked both.
What'd you say?
I worked Thursday and Friday, and yeah, I have my kid up until I go to work. And I also didn't know that my son couldn't go in there because I went over there after court. And
I understand that, but that was on Wednesday.
right. And then I worked Thursday and Friday, and they weren't open the weekend.
Did you work Monday?
No.
Then why did it take you till 3:50 on Monday to get there?
Drop my kid off to his dad. Or he can come get his kid. That's why.
So she usually starts work at 3 p.m. until 11:30, and that's whenever the father of the child takes the child. Before then, she is usually watching the child.
Well, I'll watch it. Yeah.
Tell me how I know that you weren't drinking over the week. I mean, young lady,
I don't.
you're here on a drunk driving case. I put you on a sober line, right? The alleged blood alcohol content was 0.085. There was an accident. During the course of this, you're not blowing when you're supposed to, and then I have a dirty blow. I should have sent you to jail that day, and I didn't do it. And I didn't do it giving you an opportunity to maybe show during this week that you could exist with a scram tether, not drink.
I'm confused with the last part you said because I got the tether.
Oh, I know.
Oh.
5 days late. So I guess the record's clear. Between the time of the 17th to the time you got the tether, you didn't blow into a sober link either.
Yeah, because the device locks. I didn't know if that was because
Because you were supposed to probably be on a scram.
Right.
And she did inform me of that. She did inform me of that yesterday when she tried to test on the sober link on the 18th. It gave her an error that it had to be reset.
And you did nothing.
I'm supposed to bring my kid in there. I can't.
But you did nothing. And then let me ask you this. Do you not take this seriously at all?
I do take it serious. I'm busy. I'm a very busy person.
Okay.
And that's not an excuse,
We all are.
but it's kind of inconvenient for me. That doesn't mean that I'm not doing anything. I've been coming to court
This is all inconvenient. It's all inconvenient because you decided allegedly to drink, get into a car, and have an accident. That's all inconvenient. But if true, no one in this room is the cause of that inconvenience except you.
Right.
I think her youth plays an age inside this. She's only 22. This is her first criminal case.
I'm not even 22 yet. My birthday's Friday.
So she's 21. This is her first criminal case. I do think that going forward, she's going to take this very seriously. Whenever I talk to her,
but Ms. Coons, I appreciate that. But at what point? Because if you look at this report, I have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21. Well, let's say 20 violations of basically, well, actually, it's not quite that many. It's about 15 violations of the program itself in terms of when she was supposed to blow. Then on the next one, she drank. Then, even after that, that was on April 5th. By the time we get the report, she reports back to court. I have on April 6th, she didn't test during the time frame. On the 7th, she didn't do any test. On the 8th, she didn't do any test. On the 10th, she did not test between 7 and 10 as scheduled. On the 12th, she didn't test. On 2 occasions for her testing that day, between 7 and 10 a.m. and 2 to 5 p.m., she didn't test as scheduled. On the 13th, she didn't test between the 7 and 10 a.m. She did do a makeup test an hour and a half later. On the 13th, she didn't test between 10 and 1 a.m. as scheduled. She tested at basically 2 o'clock in the morning on the 14th. She was negative. On the 14th, she then on that day still didn't test between 7 and 10 as she was required to do. And then basically 40 minutes later, after the testing window, she tested. And then later that day on the 2 to 5 test, she didn't test as scheduled. That was on the 14th. That's just this month. And then she appears before me on the 17th. I give her a break by not remanding her and tell her that she has to get a tether. And then I get here, I'm now and set this out to the 24th. And now I get here and she's too busy and it's inconvenient. Really.
I can understand the court's frustration.
Oh, I'm not frustrated. I'm just,
Yeah.
I don't get frustrated.
Yeah. Well, she does have the tether on, so it would negate any further missed test, Your Honor. If she's able to continue on to bench.
So I'm just supposed to say, don't follow anything I told you to do.
Absolutely.
Just go on your merry way.
No, absolutely not. But when we spoke, she did state that she'd like to continue this case. She'd like to stay out on bond. She's able and willing to comply with all further court orders.
How do I know that?
I've been coming to court all year. I haven't missed a court date.
Yeah, you're right. You haven't missed a court date. You've missed a lot of tests. You missed going to community corrections. You went there when it was convenient for you. Young lady, that's not how this works.
I mean, I didn't have a choice. I can't bring my kid in there.
I get the 17th. You needed to find a way to make an arrangement on the 18th and 19th. You didn't do it. In fact, so that we're also clear on the 19th. On the 18th, community corrections talked to you that day.
Mm-hmm.
And you told them that you would report to them on the 19th.
Yes, because I thought I could, but I couldn't.
That's a Friday.
Mm-hmm.
And you didn't report on the 19th. You didn't call to reschedule or offer to them, according to this report, any explanation for your not reporting. You just didn't show up. And then on Monday, even if I accept your rationale that you were working and that in terms of working, you couldn't make it, even if I accept that rationale, which I don't, Monday, you weren't working and you still didn't go until late, actually, after the agent that's assigned to your case at Community Corrections had left. And you're lucky that somebody else there stepped in and put you on a scram tether. Because otherwise you'd be showing up today with no tether.
Now we're seeing why the judge's tone shifts from concern to finality. This isn't about one missed appointment. The court just listed roughly 15 to 20 violations, missed test windows, late testing, a confirmed alcohol consumption event, and failure to report when instructed. When judges review compliance reports like this, they look for patterns. And the pattern here isn't confusion, it's noncompliance. Courts operate on structured timelines. When testing windows are 7 to 10 a.m. or 2 to 5 p.m., those aren't suggestions. Missing them repeatedly signals disregard. And here's the deeper issue. The judge already showed leniency once by not jailing her on the 17th. When someone is given a second chance and still delays compliance, courts see that as escalating risk. Let me ask you, at what point does "I'm busy" stop being an explanation and start being an excuse?
All right. Where are we, folks, on this? I did receive the email this morning, or the message this morning. So.
Yes, I did let him know about the videos and that I just received them after 11 o'clock last night, opened them early this morning. We do have all of our witnesses today. It's my understanding that Mr. Hall would be objecting to admission of the videos. As a result of that, I would be requesting an adjournment so that he has adequate time to review them with his client, and we would be able to use them at the next available bench trial date. I do want to note for the record that I did previously request all media associated with this case and was told that we had everything. So at this point, I'm not exactly sure where the gap was between that request and us receiving these surveillance videos. But at this point, I did not receive them until after 11 p.m. last night.
Your Honor, I received them at 8:30 this morning. Once Sister Counsel told me that they were in my inbox. And according to the police report, they were downloaded on January 24th of 2023. So they
Downloaded to.
police report just says they were downloaded. I'm not sure if it was to evidence.com or where it was downloaded to. That would be my assumption. And this case has been going on for nearly 15 months. So I would also object to the adjournment.
Your Honor, I checked evidence.com yesterday. I had 4 videos, actually, or 2 videos, I believe. I did not have the surveillance video yet.
And these, the description that the court got was that they're ring videos of, what are these videos? Yes. Ma'am, you can have a seat. No, you can sit right there. Okay, it's okay. They have to stand, but.
They're surveillance videos of the victim's home.
From where? No, I mean, I guess I'm trying to figure out.
It's surveillance videos that are ring videos, which the ring systems are operated by the victim, equipped to his home, and include video of the alleged conduct by the defendant.
And those are the only videos in this case.
There's body cam, and that was already submitted and uploaded into evidence.com, which was the video that I had available to me prior to 11 p.m. yesterday.
That's what I'm trying to figure out. What I'm trying to figure out is, Mr. Hall, when you reference something in the police report that says the video was downloaded, are we talking that video or are we talking other video?
It says David David emailed me his surveillance videos of his front and backyard.
Got it.
I downloaded them on my computer.
My understanding, Your Honor, is that they were downloaded to the internal Pittsfield public safety server, but not uploaded into evidence.com. I don't know what the gap was when I asked for all media associated with this case, why they were not uploaded.
Did we ask why that happened, or?
I have not had an opportunity to hear back from them as to why that did not happen. That was not my understanding of the case.
And you viewed the video?
Briefly. I had viewed the original video, which is body cam of the video on a computer.
Say that again.
So
The other videos you've seen and viewed those.
body cam video, yes.
Right. This video is the one that you're saying you just saw this briefly.
Yes. The ring videos, they're much clearer and
They're clear.
yes. Those HD cameras now.
Yes. I have like 8 of them. And your grounds for objecting to the adjournment is solely because of length of time, as opposed to.
Well, that and yes, and this case there was a plea offered and entered into at some point, and then that during the pre-plea version, that plea was pulled, and it continued on the trial, and a resolution was never reached.
I don't think that's an accurate statement of what we heard at all. Plus, we don't do pre-plea diversion in this court.
So I don't know what that is.
Maybe it was just a regular diversion.
There was no diversion in this whatsoever.
Yeah, I can help. This was a case where Patricia Reiser had offered, and she was to complete a mental health assessment and recommended recommendations of a therapist, along with do not violate the state law for 3 months and no contact with the brother for 3 months, that the case would be dismissed. My client did, or Miss Julian did do everything required under that. However, after it was completed, the plea was essentially pulled. She was no longer able to do that.
Your Honor, we have been over this multiple times. There was no note of that offer whatsoever made.
Well, I understand that, but.
It also wasn't discussed with the victim whatsoever.
Well, that may be somebody else's issue. All right. So.
And after.
Was that offer given?
Your Honor, I have not been able to confirm either way, but what I do know is we had went on to additional negotiations afterward where another offer was formally recommended, offered, and discussed, and we had agreed on it.
No.
Your Honor,
If the offer, so.
Patricia Reiser, in the case, me and Morgan Barroso were on a Teams chat. She did confirm that the offer was there, and that was the offer on I think it was the second final settlement date.
And Miss Julian also did the psych evaluation. She completed it, and a report was produced.
And I do have that report available. I can print it off if you'd like.
That was not my understanding of the communication with Ms. Reiser.
Okay, so hold on a second, folks. If I guess, was there, Ms. Kuhn, something to your understanding or anybody's understanding that if that offer was made, that as to a reason why it was pulled?
Because the victim did not agree to that.
And
The reasoning that was given.
And there was a change in the APA.
Yeah, and
There was a what?
Change from Patricia Reiser to Morgan Barroso.
Yeah, it wasn't that the victim didn't agree to it. The victim was never consulted about any resolution whatsoever, which he is entitled to because he claimed his victim rights under the Crime Victim Rights Act.
But that's not my client's responsibility to make.
Well, okay, I get that. I hear all of that, but I mean, I guess the problem that I have outside of the alleged victim, their approval or their whatever, at some point, Ms. Julian is told to do something. She's told to do something that is sort of the ultimate resolution. That being, the case would be dismissed if you do these things. It's not, if you do these things, we'll give you a misdemeanor or something along those lines, that you still have to plead to something. For her, it goes away. And so then so from my understanding, and folks can correct me if I'm wrong, she does those things.
Correct.
At that point, then, I guess, the victim is contacted, the alleged victim is contacted, doesn't agree. And then and so then that offer doesn't happen. There's something wholly wrong with that whole scenario.
Your Honor, my understanding is not that the victim was contacted, it was that there was no documentation of that offer whatsoever. And the victim
but Ms. Barroso, that's not my issue. My issue is that there was an agreement to do something. Defendant does it. Now, if on that side, what you needed to do wasn't done, that's a whole other thing. But I don't. Court stands in recess.
All rise.
Yeah.
You guys got through that. You got through what the communication I have. All right.
That is not correct.
What's not correct?
That she did not complete it.
That what?
That she did not complete it. I went back through my emails, and on February 8th, prior to the February 9th final settlement conference, I forwarded along what Ms. Coombs sent me about what Ms. Julian had done to FAPA Riser and asked her this past muster for an offer if there was one extended, and I never received a response. There was nothing from Ms. Riser. There was nothing documented about an offer. There was nothing documented about a dismissal in our file. Without anything documented in writing about an offer or a dismissal, we appeared the next day and we had the conversation in your chambers about how I didn't have any information about it, and without any confirmation, I did not feel it was appropriate to dismiss the case, so it was set for bench trial, especially with the victim being present on that day.
Okay. So, okay.
Your Honor, I have an email here from Ms. Coombs to Ms. Julian on December 8th, and it specifically outlines the plea offer, no contact with the victim, no violation of state law, and get a mental health evaluation. And then I also have a mental health evaluation that was done on the 28th, and then a follow-up from the mental health coordinator on February 1st. And
I don't think the people are, I mean, from what I'm hearing, she's not disputing.
That was conveyed to Ms. Riser. I just did not receive anything saying that that was an offer from Ms. Riser, that was confirmed. I understand that Ms. Coombs is saying that there was a Teams message on the day of final settlement. My that Teams message was not explicit that that was the offer that was extended. I did not understand it that way.
Your Honor, if I can, I laid out the offer inside the Teams message and I said, can you confirm this is the offer? To which Ms. Riser replied, yes, that is the offer. To which Ms. Barroso had replied, the victim did not consent to that, and that was the issue.
We don't have.
And then it wasn't until February 9th, which is the day after the 3-month period had run, and Miss Julian was coming to court thinking that her case would be dismissed that day, when the rug was pulled out from under her and the offer was supposedly withdrawn.
On what day?
February 9th.
I'm not disputing any of that. I'm doing the best with the information that I have that was not confirmed to me.
I mean, the agreement was that she completed the
Folks,
the 3
folks,
things.
everybody stop. Everybody just stop. I get what the agreement is. I have now this communication from Ms. Reiser that's her recollection of the agreement. I also have at least confirmation and my understanding that Ms. Julian did what she was supposed to do under the agreement of the parties, or that was between the parties at some point. The issue here, however, is, I guess, that the victim did not or wasn't consulted about it. But that's not what I am taking, and I don't know if we need to have Ms. Reiser here. This is certainly her recollection, but specifically in the communication she sent, Ms. Reiser was of the belief that the victim has said that they were okay with that resolution, and that ultimately out of all of this, they wanted to be left alone.
Yes.
But now I'm hearing today that the victim is not okay with that resolution.
My understanding is that resolution was not even raised with the victim as a potential resolution.
Donna, the victim was at the final settlement conference. From my recollection, there was a conversation on what his solutions was at that time of mental health and the no contact, and it was a creative solution. The plea was.
But you weren't. I understand what you're saying, Ms. Coons, but you weren't a part of that communication. You believe that there was a communication that may have taken place either with the victim's advocate or with Ms. Rice, with the alleged victim in this case. Is that right? I mean, you're giving me your impressions of what you thought a conversation that happened.
Correct, but I was not a part of that.
And on this day, I'm presuming the victim is here.
Yes, he is.
He is not okay with the resolution that was.
After all of this, he says whether we have the trial today and go forward with it or dismiss it, he is going to just be seeking a PPO. He says he's just tired and just wants to be left alone. So if we're not proceeding today, that's fine. If we are proceeding today, that's fine. He's been run through the ringer. He just wants to be left alone and will be seeking a PPO, whether it is stipulated to or not. That's all that he is caring about at this point.
And based on that and everything else, Your Honor, I would move to dismiss.
Well, I get to deny your motion. Okay, I could dismiss it. Because the agreement, there's an acknowledgement of the agreement, but, and I had my staff check too, because if the agreement had been placed on the record, then everybody would be stuck with it. It wouldn't matter. But so my understanding now, I guess, based upon what you said, Ms. Barroso, is that the victim in the case is indicating exactly what Ms. Reiser has said. They said that they just want to be left alone.
That is the first time he has said that today. In all of my conversations with him and all of my advocates' conversations with him, I was speaking over the case. That is the first time I have heard that out of him. But at this point, he's now appeared 3 times and he's done.
Well, maybe not. what I'm inclined to do is your client was trying, I don't know if she was trying to say something to you. She may want to mute the microphone if she's saying something.
They haven't had contact in over a year and a half, so it's not like, she's stalking him or trying to get a hold of him. She doesn't want contact with him either.
Can I talk? No?
Well, here's what I'm inclined to do, folks. What I'm inclined to do, and I will be very careful how I say this, but I'm inclined to disallow the evidence that was just provided and exclude it from any trial and just proceed to trial on the matter if the parties can't come to some resolution. In doing that, I want to make it very clear that I'm doing that because defense counsel just got that information, but in no way am I making that ruling attributing that there was any indication that the Pittsfield Department of Public Safety or Officer Richler was attempting to try to not provide that information. And I say that because this officer's been before me for a couple decades, maybe. I don't know. 20. So right after I started. So in a quarter century. Anyway, and has always been forthright, would not engage in anything to withhold anything. I would see it as being an error, but that error in terms of it happening and then ultimately
5 days in county jail, not for the original DUI charge, but for violating bond conditions. Let's break this down clearly. The court had 3 core concerns: repeated missed alcohol tests, a confirmed dirty blow, and a 5-day delay in getting on a court-ordered scram tether. In drunk driving cases, monitoring isn't optional. It's about protecting the public and ensuring compliance. The judge made it clear: every defendant has responsibilities, jobs, and family obligations. But once a court order is issued, compliance is not negotiable. This wasn't about frustration. It was about accountability. The court gave an opportunity to prove responsibility, and the pattern showed otherwise. Now I want to hear from you. Was 5 days fair? Too harsh? Or exactly what was needed? If you found this case as intense and eye-opening as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Of it happening and then ultimately getting corrected has inured to what may be a not a benefit to the defendant, and certainly may cause, so I haven't seen the tape, so I don't know, but may cause some issue. So what we'll do is I won't allow it. We'll proceed to trial. And you guys have 15 minutes to get yourselves ready, and that's what we'll do. Fortune possession. And there's been a in-chambers conference. I'm going to adjourn the trial out to, what date is that?
May 1st.
Jury trial to May 1st, 2024 at 9 a.m. That's a special time. All right.
Just to put it on the record.
Yes.
If I get the order signed before then, the hearing will be.
The trial will be canceled.
And the case will be dismissed.
Dismissed. Is that correct, Mr. Hall?
That is correct, Your Honor.
All right, very good. We have that all on the record. Okay, thank you, folks.
Thank you.